This episode of AHLA Speaking of Health Law is brought to you by AHLA members and donors like you. For more information, visit AmericanHealthLaw.org.
Hi, and welcome to an AHLA podcast. I'm Kierstead, Director at VMG Health and on the Academic Medical Centers and Teaching Hospitals Practice Group. Last November, the practice group pulled together several folks to put together an article that appeared in the November-December issue of Connections titled Key Legal Issues in Academic Medical Center and Community Hospital Tie-Ups. We have Joseph Keillor from Baker Donelson and Carrie Amezcua from Buchanan and myself to expand on a few of the issues raised in that article. Thanks for joining us, Joe and Carrie. While there's a range of definitions that constitutes an AMC, in this article, we really just tried to focus on a range of dimensions that, while not necessarily unique to AMCs, they do pose unique challenges in their interpretation and resolution. These affiliations present a variety of institutional, cultural, and legal and regulatory challenges. Both developing and negotiating the deal structure at the outset is important, but also planning the integration, implementation, and really the preferred final state deserves equal attention. So we're going to pick up on a couple of the topics noted in the Connections article. First, Carrie, if maybe you could highlight some of the key issues in antitrust for us.
Sure. Thanks, Red. Hi, everyone. I'm Carrie Amezcua, shareholder here at Buchanan, and my practice really intersects antitrust and healthcare. And so when we're thinking about antitrust in the context of an AMC combining with a community hospital or combining with a physician organization, what we're really looking for is making sure we are compliant, because the antitrust laws say that two independent entities can't restrain trade if it harms or lessens competition. An extension of that is two entities can't combine if that combination would lessen competition overall. So in practice, what that means is that two independent entities, so let's say your AMC and your community hospital, they need to be careful on what information they can share and how they can work together in a collaboration of any kind, really. And that's important because there are civil penalties and even criminal penalties for violations. And private plaintiffs can also bring suits. And so the antitrust agencies, primarily the Federal Trade Commission, they're looking at these collaborations and they're saying, is that collaboration going to be good for patients and payers? Or is that collaboration going to reduce competition for healthcare services? In a certain market, usually we're looking at like a defined small-ish geographic market, counties, metro area. And we're seeing more and more state attorney generals getting involved in healthcare transactions, like Pennsylvania, where I am. And we're seeing more states enact pre-merger notification laws directed specifically at healthcare providers. So there's a lot goes on with antitrust, but I'll stop there. Turn it back to Rudd.
Just a quick question, Carrie.
Yeah.
Is there any particular motivation for AGs to get more, call it proactive in some of these in their efforts?
Sure. Well, by definition, right, healthcare services are local, right? And so states really have a vested interest in making sure that the healthcare providers in their states are competing fairly, are negotiating with payers fairly, right? Because your negotiations with payers are going to trickle right down to what the patients pay. So unlike some industries that are nationwide or global, state AGs really have a vested interest in, protecting that competition in their state.
Right. Joe, some of the main themes in fraud and abuse for AMCs and community hospitals, what comes to mind for you?
Well, so the big regimes are always the Stark Law or the Physician Self-Referral Law, and then the Anti-Kickback Statute. So here, the Stark Law or PSL is going to be most relevant for the employed physician compensation, coming from the physician employment vehicle down to the physician. And the anti-kickback statute here in this context is really going to be relevant to the entity to entity flows. If you've seen one AMC, you've seen one AMC. There's a lot of different ways they're structured, but in many cases, it's not all housed in a single legal entity. In many cases, at least the teaching hospital and the faculty practice plan and or other physician employment vehicles are in separate legal entities. And so you commonly have these entity level flows that generally won't implicate the Stark law, but that will often, there will be a kickback analysis there. And so where it comes into the mix is that for a couple different reasons, I'll just foreshadow one of them, simply because you may have had your main systems and ways of doing comp. And the community facilities that you may be acquiring or affiliating with may have had very, very different ways of doing physician compensation, and you may or may not be changing that. I think Rudd, you may speak to that, but to the extent that you're largely not changing that, right? There may be entire new systems and approaches to comp, and that may be a different Stark analysis than you've been used to.
Yes, we see that frequently, and it's often an unresolved conflict, really. It's very complicated and very visible, and it's a huge challenge for folks. The thought of changing everyone's compensation orientation is hugely challenging. It depends to some extent. The challenges can depend on where the actual physician entities end up in the affiliation. Do you have completely separate entities, or do you have some common entity? And then, of course, the extent to which you have faculty and community physicians rubbing shoulders also makes a big difference. So definitely thinking about some of these practical, call them operational, real world issues as you're going through that initial process will pay off in the end. At least knowing where the differences are and where they're going to surface is a key first step. So at least you have a roadmap post-transaction or post-affiliation. I think that's a great point to bring up. Joe, do you see also between leadership that you work with in these transactions when it comes to fraud and abuse, a change in thinking that has to happen there? Whereas before the transaction, community folks thought one way and maybe need to start thinking a different way. Same for, or in a different way, perhaps for the AMC side of things. Do you see a shift in thinking that needs to happen?
Well, the biggest thing is to figure out what framework you're under, or could be under. So in the article, we talked about figure out, is your physician organization or which ones, if you have multiple in your physician enterprises, are they or can they be a Stark group practice? And so there could be situations where you aren't really sure, or you haven't had to think about it as an AMC, but depending on the features of the comp model that you want to pull in, it may be time to think about it. Similarly, it's a really important question to ask. Do we have a Medicare Shared Savings Program, ACO, that's a part of our enterprise that we could pull in and capitalize on the Medicare Shared Savings Program waivers? They're the singular most flexible set of fraud and abuse waivers. They waive the physician self-referral law and the anti-kickback statute law, and the anti-kickback statute if pretty straightforward parameters are met. And again, it can be a situation where this never came up for your AMC because it didn't need to. And you designed your comp plan 7 years ago. It's worked. It never needed to be brought under the waivers. You've had an ACO now for 4 years, but you never thought about it. And then now, in order to bridge that gap with the community physicians, now you're realizing some risk levels where, oh my gosh, maybe we do want to capitalize on the MSSP waivers. And so it's just what has worked, the frameworks that have worked before, which might not have relied on either, start group practice or MSSP waivers. Those frameworks might not work anymore. And it might behoove the organization to capitalize on different frameworks, or at the very least, do the analysis to conclude that you don't need to change.
Right. Carrie, what do you find are some of the different factors or different ways of thinking that the different entities need to take on or should be asking themselves?
Sure. Well, from an antitrust perspective, from any perspective, really, there's a continuum, right, of what you can do together. You could just have a contractual arrangement. You could be an affiliation. Or you could do a full-scale acquisition. And so when you're deciding how you want to work with community hospitals or physicians, you really need to figure out, what your goals are. How much integration does each party want? How much control is that community hospital or physician group willing to give up? How important is joint contracting with payers? That is the single biggest question, right? Does the community hospital or the physician organization want to come under the AMC's contracts? Do they want to be able to joint contract and get those payer rates? If you do, it's a bigger analysis on how integrated are you and how much control, you meaning community hospital, how much control are you willing to give up? If that doesn't make a difference to you, then you can do a lot of other things too. So each type of collaboration has different factors to weigh, but I think it's important for both the AMC and the community hospital or the physician group to really sit down and figure out what are our goals, what are our priorities, because that can drive not just antitrust, I think, but probably a lot of the other questions too.
And I imagine, or I've seen that it's not always the case that both parties see the same way on every issue.
Right.
What are perhaps some of those key questions that go unanswered that should be answered, maybe?
Well, like I said, usually it all comes down to the biggest thing is joint contracting, right? But also, if you're not doing a full acquisition, right? If you're just doing an affiliation or if you're doing a joint venture service line, are you going to be able to adhere to the antitrust guardrails that you're going to have to put in place on a go-forward basis, right? Because if you are not one combined entity, then you have antitrust risk throughout your existence. You will have to adhere to certain antitrust guardrails going forward. But if you're going for a full acquisition, that's time consuming and you got to go through due diligence and your regulatory approvals. So all of those things, like you said, I think, a community hospital may have a different view than an AMC, but they can all be worked through, right?
Mm-hmm.
And there's different ways to set up those collaborations or affiliations.
Right. Joe, what do you see as some of the balancing act steps that folks need to be aware of?
Well, so for example, it's with that start group practice. If you can be a start group practice, then fair market value is for Stark purposes out the window with respect. It's not an element. So, however, I say that with the utmost caution because typically in these, you may have tax issues, but I'm not a tax lawyer. I'm not going to talk about that. So within the typical AMC enterprise, you are going to have multiple entities, and you're going to have those mission support entity to entity level flows. And those are low risk or essentially no risk under the anti-kickback statute if you're hitting the different pieces of what I call the academic medical center framework under the AKS as expressed through a series of OIG advisory opinions. There's about 4.5 key advisory opinions that form this framework. They identify a handful of elements that you need to be hitting to be under that framework. And for those big entity to entity level flows, that mission support or other monies to be legal and not pose significant risk under the anti-kickback statute, you're going to need those payments from the physician employment vehicle to the physicians to be consistent with fair market value. So I have clients that say, well, why do we try to why do we try to do the analysis to decide that we're a start group practice then if it doesn't really help us for kickback? And again, it's just that balancing act. If you have 1,000 physicians and there's some competitive areas, me personally, I would love to have a backstop for 5 physicians, right? That the government comes along and says, well, we disagree that you kept it within the tippity top end of the range of FMB. For these 5, we think you crossed that line. I would much rather have a magical elixir that gets that to go away and Stark is off the table. And granted, in theory, do I have some increased anti-kickback risk for the entity to entity level? Even if there was 5, theoretically that's driving some risk there. But I still am happy that we've taken Stark off the table. And are you really going to have massive AKS risk if the government is still asserting that 5 out of 1,000 were exceeding fair market value? But at the same time, when you just because you get that flexibility as a Stark backstop, again, you don't want to go crazy with it. You don't want to intentionally put 200 physicians over fair market value, because even though that wouldn't be a Stark problem, that's the whole point of group practice and in-office ancillary services exception. You intentionally and clearly go way over for a significant number of your physicians, and then you are really outside of the anti-kickback statutes AMC framework for those entity to entity level payments, and that $100 million mission support framework now has a giant target, neon signs saying we have a kickback problem here. So that's the balancing act, giving you a Stark backstop without then people wanting to take advantage of that and then increasing your AKS risk.
Right. And do you see those as issues that need to be discussed and resolved in advance? That seems to be implicit in what you're saying. Is that?
Well, Rudd, how lucky do you feel? Right. So yes. So it's at least at a level, well, ideally just the answer is just a clear yes, right? Of course, that's easy for me to say as outside counsel where I'm not, balancing pressures to get the deal done in, 5 months or whatever the pressures may be. So if not fully resolved, then I would say at least a preliminary analysis to confirm that the risk for an interim period is manageable and modest, and that it's not extreme, and that you can punt that at only moderate risk to the organization, and focus on that for a year post close. But yes, in an ideal world, there are some structural considerations, because what happens when you close and then you do that analysis, throughout year 1, and you realize that you should have parked the physicians in a separate entity from the get-go, and that would have been the ideal legal structure, right? And then now you're nervous. Well, do we send this letter 10 months in, and what are the stories and narratives that are going to be created when some minor letter assigning their employment agreement from A to B? Is it a big conspiracy to lower comp when it's not doing that at all, and it's just designed to put the entities in the best legal environment, when you could have come up with that on the front end?
Right. Shifting now a little bit to slightly different view, maybe Carrie, you could have some thoughts about potential landmines or hidden gems to keep in mind that folks should watch out for as they're navigating the antitrust issues.
Yeah, I think, sort of going off of what Joe was saying, right? A lot of the antitrust issues you want to take care of up front, before you sign the paper, before you close the deal, because it can put you in a much better position going forward. So that is one thing I would look out for, right? Bring antitrust counsel in early enough. They can help you set it up correctly, and then you can be good to go. The other landmine is, as an AMC grows and starts affiliating or acquiring physician groups or community hospitals, that AMC may start out with no antitrust issues whatsoever. There's no overlap. They're small enough. It's a small enough community hospital. You could be fine. But as you grow, you might then be taking up more and more of the market share. And so your antitrust risk then shifts. And so you want to keep an eye on that as you are growing.
Interesting. That sort of falls under the careful what you wish for problem.
Right. Exactly. Yes, we're bigger. Oh, well, now you have every physician in cardiology in the metro area. And there's no competition now for cardiology specialists. So
Carrie,
you do want to.
it's a slow, it sounds like a slow boil of a boiling frog, and
Yes.
and I have one of those as well. So a landmine is, so you could have an AMC that it's been used to historically it's just been a really traditional AMC, very little extra community based activity, right? So they're used to having major flexibility under the anti-kickback statutes AMC framework for those entity to entity level flows. Then it shifts, right? And it's usually a slow shift, right? 5 or 7 years of going up and down and sideways across the interstates, really pulling in community facilities. And so let's say 5 years of doing that, they've added 1,500 community physicians, right? But they still want to have major flexibility, major anti-kickback statute flexibility on their entity to entity level funds flows, right? So like at what point have they really pushed the bounds of the AMC framework too far, so that those entity to entity level flows are subject to greater scrutiny? And again, if I were in-house counsel and not a full-time healthcare regulatory lawyer, right, it would be so hard to even think about this, right? Because I'm probably going to be pretty busy during those 5 or 7 years of expansion. It's probably gonna be the last thing on my mind. But an associated gem to potentially help, right? So of those 1,500 community physicians we're adding over the years, in my experience in talking with clients, they've told me that through conversations, that you can round up or you can round down on your how you approach and the categories for pulling some folks in and giving them a very light faculty appointment. Sometimes this shows up in the clinical faculty classification. It can show up in other terminology or classifications as well. But a very, very light classification, in the hypothetical I shared, you could round down and only grant that to 200 of the originally community physicians, or you could round up and grant these very light faculty appointments, let's say to 600. And so my point is that where you can legitimately do so, and there is some modest level of supervising the residents or whatever other appropriate factor, it helps to round up. It helps from a kickback perspective to preserve the academic character of the enterprise and of its various components, to be as liberal as is reasonable and justifiable in making those faculty light appointments, and keep those numbers decent, keep the balance of them decent, and that helps you on the kickback front with those mission support monies still being pretty solidly protected under the anti-kickback statutes AMC framework.
I can also see consistency being an issue as you're doing, one in year one and two more in year two. And, I I can see it, oh, what did we do for that first acquisition? Oh, this is what we did. And like trying to keep that consistency um, throughout as the AMC is growing.
As it evolves. Yeah.
Yeah.
And Joe, you mentioned funds flow. I mean, entity to entity, yeah, but the that issue translates down to pretty much anything that happens across the legacy entities. And settling some of those issues is an issue you like to kick down. It's a can you like to kick down the road, but one that just comes back to bite you. And resolving how you're going to make those things happen is often critical to really making the affiliation actually work. Whether it's planning for those transactions that you were referring to, Carrie, and having a model of what does our institution look like when we move this along, as opposed to just acting responsively and reactively. It can be a danger. Really thinking through how do we behave as an institution post affiliation is important and important to the participants, certainly the docs, something I would definitely highlight. Um, okay. Um, is there any, Carrie, for you, any practical advice or takeaways you might offer to in-house counsel?
Sure. So, I think one of the things that people think of antitrust is that it's too restrictive and it's not going to let us share anything or do anything. And I would say that's not the case. If you can set it up correctly, antitrust applies no matter the type of collaboration. But there's, like I said, a continuum. And if you set it up correctly, the way I approach it, we can be very practical. We can, give you guidance on what you can and cannot share and how you can go forward. Collaborations can, like I said, can be really beneficial. You just have to do them the right way. And if you set it up that way, it's fine. So again, I would recommend involving antitrust counsel early. And again, really figuring out what your goals are. I've seen, physicians want to set up these clinically integrated networks, and it sounds good on paper, and they want to joint contract with payers, and that sounds really good on paper. Um, but when then I say, okay, well, you have to be clinically or financially integrated, you have to like have metrics and you have to measure them, or you have to accept the downside risk, then it's like, oh, well, maybe we're not ready for that yet. So that's, one of the things I would encourage folks to think about.
Yeah, great. Joe?
Yeah, so we do a lot of work helping AMC design or overhaul their physician compensation policies and thinking through funds flow issues. But as those issues may be heightened by community tie-ups and even in steady state also. But so I guess some questions I would pose to the in-house folks is to you consider reflecting on, do you have a policy or at least an internal legal department memo clearly articulating your legal frameworks, for physician compensation, such as which, if any, your physician organizations are deemed to be a STARP group practice, as well as your internal parameters for how much are we going to lean into various dimensions of the flexibilities that then we can get through that on the Stark side of the house. Do folks in the legal department have a clear understanding between the interplay of legal considerations relating to compliance of employed physician compensation on the one hand, and then anti-kickback statute compliance of the entity to entity level funds flows, the interrelationship between the two? Do folks appreciate that those two things affect the legal analysis? There's an interplay of those respective legal analyses. Is there a primary mission support document between, for example, perhaps the teaching hospital and the faculty practice plan entity? Do attorneys in the legal department know where to find that? Do they have some sense of its primary contours? If there is that document, Do folks know whether the organization permits ad hoc entity-to-entity flows that are not consistent with fair market value? Now, that's technically not forbidden by the AKS's AMC framework. Some of the core original OIG advisory opinions establishing that framework were ad hoc flows and not a massive master mission support agreement. I would stipulate that today that's not a best practice. But setting that personal view aside, I'm just merely backing up and asking the question: does the legal team even have a solid understanding of the organization's approach? One other question, do attorneys who are working on community facility acquisitions, do they realize that there could be implications for the legality of existing entity-to-entity level funds flows? And if that's not their primary area of responsibility, are they talking with other attorneys on the team who are responsible for managing and ensuring the legality of entity-to-entity level funds flows? So, I rattled off 4 or 5 questions there. If your legal team could truly say yes to all those questions, and congratulations, in my humble judgment, that probably places your team in, maybe the top third of all AMC legal teams. And if not, there may be some opportunities for internal education and/or policy development around, what are really subtle issues, and which to me, are understandable, may not be top of mind necessarily for folks with a day job in their duties in the AMC legal department.
Right. Great. Carrie, any last thoughts before we sign off, I think?
No, I was just going to say, similar to what Joe said, do the antitrust analysis up front, get it done early, so you can set up your collaboration the right way.
Yeah, absolutely. Well, thank you, everybody. I look forward to the continuing conversation, and thanks for joining us.
Thanks, Red.